Item one for orders.
May please, your lordship.
Oh,
Lordship, at this is notice may go, lordship. At this is notice may go, lordship.
where's the order?
It starts from page 13, lordship.
13.
Lordship. And relevant part starts from page 15, lordship.
It's an order of 2022.
Lordship, thereafter what had happened, lordship? Thereafter the state government, lordship. Kindly peruse page 17, lordship.
Oh,
Thereafter, the state government had submitted the proposal before the additional secretary Assam Legislative Assembly, lordship. Assam Legislative Assembly, lordship, as per direction of this honorable court. But the Assam Legislative Assembly are sitting over the matter for a reason best known to them, lordship. In this regard, we have recently submitted several representation, lordship.
so you should have come to court at the relevant point of time. Why you are coming now? It's
Because-
more than 1 year.
Lordship,
It's what by limitations, isn't it?
RTI report is of 2/5/2024, lordship. At this stage, notice may go only, lordship. Because RTI report is of 2/5/2024, lordship, which is page 25, lordship.
See, the issue is when the order was passed in 2022,
Lordship.
when they were not taking steps, you could
Lordship.
have approached this court.
Lordship, we have approached the concerned authority several times, lordship.
You
And
should have approached this court, not the authorities.
lordship, and the last time I have approached on 3/4/2025, lordship. Because state government has done his part, lordship, but the matter is pending before the Assam Secretariat, lordship.
Who are the respondents?
Only the secretary, lordship,
Secretary of,
Assam Legislative Assembly, lordship.
was he a party in the PIL?
Lordship, but direction was given to them, lordship.
Where's the direction?
Lordship, it starts from page 15, lordship. Para 5, lordship.
No, we can't issue notice. You think over it,
Lordship,
you think over it,
next week, lordship.
on request made by Mr.
Keyboard, lordship.
Then the council. List down
Next
after a
week,
week,
immediate,
after a week. You think over it.
lordship. Oblige, your lordship.
No. Okay. David has come. In the,
No, please. I'm appearing for respondent number 3 and 6 here.
3 and 6 years,
We had filed our affidavit, but it is not on record.
3 and 6.
The interim record is here. Our interim application in their counter. I think you have filed. Yes, it is there. It is there. Yes, so I'll confine to the interim record. May I?
Yeah.
May I, Milord? Milord, it's a short point. Milord, the petitioner completed his tenure as a judge of the High Court, 96 to 2000. Then he was appointed as vice chairman from 2000 to 2003. These are two different assignments under two different, this is one is under the constitution, the other is under the administrative tribunals. We were given pension under the 54 Act for the High Court judges. Also, the pension order was issued so far as the second assignment as vice chairman is concerned, that was given. because under the Act, Section 10 says that you are entitled to a pension. So I have served for 3 years, I am entitled to pension. So they were giving so far. Suddenly, we get a letter in 2025 saying that if we club both the High Court pension and the CAT pension, it exceeds the total payable pension to a High Court judge.
But then
That is where they made a mess.
I think there are already some adjustments to that.
Kindly, that's why I am giving your lordship the second order of this Honorable Court, which is dated 26/5/25 for a minute. It has crystallized the whole point in very 26/5/25. That's the order of the division bench earlier hearing the matter. So and so learned Central Government Council puts in appearance on behalf of the respondents 1 and 2. I skip this first paragraph, the council's names and all that. As a second paragraph, as a matter of fact, the applicant has not prayed for any relief against respondent 578 and has only prayed for relief against the remaining respondents, and therefore requirement of service of notice upon the respondent 5 and 8 is at present waived in so-and-so as well as in connected with petition number so-and-so. The matter pertains to deduction of rupees 57 lakhs from the bank account of the applicant on the ground that he is in receipt of excess payment of the said amount against his pension. The applicant is a retired High Court judge and has also served as a vice chairman of the Central Administrative Tribunal, Guwahati branch. For 19 years, Milord, this notice says that you have to repay, the amount is 57 lakhs and odd, after 19 years of payment. The respondents have acted under the presumption that the applicant cannot get pension for both the services, that is as High Court judge and vice chairman of the CAT, Guwahati, and after clubbing the same, have concluded that the applicant is only entitled for pension of a High Court judge and is not entitled for pension for his engagement as vice chairman of Central Administrative Tribunal. Prima facie, we are of the view that the action of the contesting respondents is not in accordance with law. The matter is already settled up to the Honorable Supreme Court, C so-and-so 95-6 SCC 765, 94 Supplement 3 SCC 502, and AR 2003 SC 3887. And decision passed by the single judge of the Kerala High Court is giving the reference. Reported in so-and-so. When it is held that both the services, that is as High Court judge and chairman, vice chairman, member of the Central Administrative Tribunal, cannot be clubbed. So that is already settled. I don't know how they have, after 19 years, suddenly they wake up and say that, all right, this is, you are not entitled.
Chagawati?
Only appeared for respondent number 1. For respondent number 2, service has to be complete. On the very first day, lordship will find and the order dated 14/5/25.
Which order?
And the inspection came from respondent number 2 is that they will have their own input.
It is all right, Milord. On the merits, I am not saying your lordships can hear the matter in full, but we have filed an interim application without any notice to us. They have deducted not only from the pension account of SBI, but there was another account of ours in SBI. From there, the balance amount was taken from that bank without intimation to us, without information to us.
Yes.
Yeah, and I'm happy to say, and I'm happy to say that in the interim application, they have filed, State Bank of India has filed an affidavit where they say that if the court grants, we have no objection to return the money.
Okay, returning the money is other thing, but then they've already deducted 57. No.
That is why our prayer is that I direct them to return the amount from the two banks.
Is
it a joke, Milord?
That cannot be the interim.
there are two issues. They have
What
stopped
is
the
the
pension
addition you
and they have recovered the money from our two bank accounts of SBI. One where pension was credited and they could not, they have emptied the entire account, and the balance amount which was there, which is a separate account in SBI in a different bank, below in the High Court extension. From there also they are taking away money without informing us. Unthinkable, Milord.
Yeah.
So let them redeposit that money. They don't want to pay the pension during dependency, very well. Let them not pay during dependency. Your lordship will decide
So
after
far,
hearing.
where's your
But so
affidavit?
far as this money is concerned, it should be returned.
You're not appearing for number
For
two.
two, I'm not appearing.
Then
So on the very first day, I entered every lordship and the Ferus order dated 14/5/25.
Hmm?
Let the notice go to respondent number 2 by this.
No, no. If response number 2, we have served. We have served.
you've served on two.
No, no. You
On
may
the
not
very
be-
first day, I appeared for respondent number 1 only. And the Ferus order dated 14.
No, even response number 1 is both 1 and 2.
That has been recorded in the order, but that is.
No, it says let notice be issued to the remaining respondents.
Yes.
So that
And we have justice service.
Lordship may can
We have filed that affidavit.
In the rate petition.
Oh,
Lordship can be said, Ferus lordship.
14/5/2005 order.
Yeah.
You appeared for one.
For 1 only.
And then the next para said let notice be issued to all the remaining respondents. So all remaining respondents should include respondent two.
Service has to be complete, lordship.
We have filed the affidavit, justice service.
Where's the
Both the respondents were served.
For 2 lordships from Delhi.
Yes, Delhi. We served.
in Delhi.
By justice.
Yeah, yeah. We have given an
Then it is
affidavit.
okay.
We have given an affidavit. No?
No.
Affidavit of justice service to the respondent 2 and 5.
Well,
You can only serve the affidavit. You can give the affidavit. Therefore, I am not on the merits at the moment, but
okay,
in
yeah.
our interim application, we are saying that this is not the way you can take away money from a man's bed. So you return the money and then your lordships they can file whatever affidavit they like, your lordship will hear. But this can't go on like this. How a second account where there is no pension amount, they are even taking it from there.
Senior counsel, that would be granting you the whole relief that you have asked in the relief. What we can do is,
We are asking only for returning the money to the accounts from where they have taken. That is an illegal, and the State Bank in their affidavit, I'll say very fairly says that if the court orders, they will immediately.
Because it is in the government account.
Correct.
Because we are only a facilitating agency.
yeah, that is a different thing, but we need some,
Yes.
we need some affidavit from you.
From respondent number 2, there will be the appropriate authority.
Oh, who is appearing for two?
The letter says they will engage their own conflict, they have interested the administrative tribunal, register administrative tribunal to defend the case.
That they can have the luxury of the time and do whatever
We
they
will
like.
give them,
but
we will give them 1 week time. If they don't appear, then we'll.
No, we have
Pass on.
served on respondent one.
Don't take any coercive steps.
Huh?
Don't take
Respondent
any.
number 1, he took the notice on
No,
the
no,
first.
he is there,
Huh.
but he can't appear for two.
2 we have served.
Two you have served, that's fine. But he can't appear for two.
Correct,
because,
correct.
they have
That's his-
said that,
that's
they're
his
engaging
lordship
some
there.
other account.
So all that I want today is that your lordships may consider our interim application and ask them to return the money to the two banks as they took away. They may not grant the pension, continue to grant the pension, that's different, and that can remain for the final hearing. But this is something which is unheard of, my lord. You take away every penny from one account of
No,
pension.
this, IA, you have taken justice service.
Yes, yes.
In the IA also.
I also.
I don't think so.
We have quite a few dusty affidavits we have,
In the IA, only 3 and 6 you have taken.
and they have filed an affidavit. At least the bank.
3 and 6 you have taken.
Yeah.
I
No, 1 and 2 we have given. In the first order itself, it was mentioned.
in the IA notice has not gone to respondent 2.
No, it has been served. He is appearing.
He's the bank.
Yes.
That is 3 and 6.
Respondent B, Secretary Learned Central Government Council puts in appearance on behalf of respondents 1 and 2.
It has been reflected in for I appear for 1 and 2, but I can
Yes,
only appear for
Dr.
respondent number 1.
No, that is different. I am going by record. And Learned
No.
Council puts
In
in
the
appearance
first order, 21/5/2025.
21,
5/2025.
21, 5. Order. First order. The 21/5 I have already read out. Man. This is 14/5 is the first order, second order 21/5. 26/5, I am sorry.
What you,
14.5 order is in the written petition.
14/5 is the written petition.
Correct.
In the IA, the first order is 21/5.
Correct.
Just check up. The notice has not gone to respondent 2.
A was filed and then 26/5. You know, 26/5, 25 is the IA they are considering.
21/5/2025 order.
There are two orders.
She should be.
Hmm?
Yeah, we're giving you a copy. You can check up.
Two. My lord is talking about 2, respondent 2.
This is the main respondent.
Hmm. 3 and 6 has been served. Your lordship is right, my lord. It is the
Notice has not
Secretary
gone
Learned
to-
Government Council appearing on behalf of respondent number 1. And so, hence no formal notice is required. Let notice be issued to respondent 3 and 6.
2 is not served.
3 and 6 have been served, sir.
3 and 6 is served.
The-
Two notice has not been sent.
2 is 2. Who is he?
2 is the
one.
main respondent.
No. We'll just kindly proceed with your other matter. We'll just check up and tell your lordship. Because there are 3 or 4 dusty service affidavits. I'll just.
No, I've seen the dusty service in the writ petition.
Yes.
They are complete.
Huh.
That's not an issue.
Huh.
But in the IA,
Yes.
notice on respondent 2 was not sent.
I'll just check up. Your lordships can just give us a little time. This. It is my lord's.
Here we can issue notice. Parliament matter.
Wait, Your Lordships. This is a writ appeal against an order of learned single judge in a tender matter. Lordship knows that the Supreme Court has all along been saying that in tender matters, there has to be openness, transparency, and fairness. Now, this is a case wherein Lordship will see from the facts of it that the entire tenets of this good ethos that the Supreme Court has laid down has been violated in very blatant manner. If I may just place what has happened, just a summary. This is basically an NIT for construction of a road under the PMGSY scheme. Now, therein, there is an SBD. The SBD provides the entire methodology as to how the bidders will be evaluated. This is a two-bid system, and the bidders will be evaluated on the technical aspect and then the financial aspect. Now, the clauses of the SBD clearly states the methodology as to what papers will be looked into, how it will be evaluated, and thereafter, once the technical evaluation is done, then the financial bids will be open, and therein the most suitable, the lowest bidder, will be given the contract work. Now, herein is a case wherein the entire process was followed, and the petitioner who had quoted a rate that is minus 3.5 of the estimate, which is within the range, was found to be the L1. Suddenly, thereafter, the work order was issued to the L2 bidder. Now, that L2 bidder's work order was, however, not uploaded in the web portal. So we had to file an RTI. Now, in the RTI, they give us that work order, and along with that, they give us a minute of a meeting, which I will place. Now, that minute of a meeting, which does not draw any confidence, if I show to your lordships, it's just one plain paper signed by two persons, dated prior to this NIT, and says that the methodologies prescribed here is what has been applied in the evaluation process. And by applying that process, wherein marks were given, some allotment of marks were given, the L2 was made L1. He was given 100% marks in the technical bid evaluation. I was given 70% marks. And based on that, the entire scenario was changed. And from L1, I became L2, and it was entrusted to him. So this is what has happened. My entire case is that these were hidden criteria. This methodology was never prescribed in the NIT, and therefore the entire process adopted by the authorities was not correct. If I may now therefore place
Where's the minutes?
yes, Lordship. The minute Lordship will find at page 515. $514. Hospitals got that? This is a minute that the authorities are trying to rely upon, saying that this is the methodology that they have ultimately put into application. Now, this document does not draw any confidence. Well, Lordship will see. Neither does it have any memo number. Neither it is an office circular. Neither is a memorandum, or for that matter, any kind of a notification. It is shown to be signed by two officers, and it says copy to all the member concerned, office copy. Now, this NIT.
Where's the NIT?
Yes, Lordship. NIT was issued as page 80.
What
The
is
NIT
the-
was
what is
issued
the-
on
10,000.
22/10/2024.
So this minus was before the NIT was issued.
They say that this minute was there before the NIT was issued. So therefore, my case is, if at all you had a methodology, it should have figured in the SBD, because the SBD clause categorically states that if you want to incorporate something, it has to be through way of an amendment. I'll place those, Lordship, because I'm praying for a status quo order also. The SBD says, if you want to bring in something, it has to be through amendment. The SBD also stipulates the methodology as to how the evaluation is to be done. So therefore, how could they now today on an RTI come up and say that this is what they had used? As if the Supreme Court in Datta Associates and also our division bench in Educom have categorically stated the methodology has to be clearly mentioned to the tenderers, either in the NIT or by way of an amendment. Here is a case wherein these principles of the Supreme Court has been blatantly violated. And the Honorable Single Judge have held that since this minute was there prior to the NIT date, therefore it should not be a document that would be regarded to be a hidden criteria. If it was never published, if it was never brought into amendment, how is it that it will come to our knowledge? Only in RTI they bring it. But the learned single judge have held that no, since it was a minutes prior to the NIT, therefore it should have been in your notice. That probably analogy will not be correct because an office minute, which is not even taken the form of a notification or a memorandum, how is it supposed to be in our notice? The fair, transparent process of an NIT would stipulate that it has to be brought in the NIT by way of some clauses, by way of some amendments, if at all. It's not been done. If your lordship will therefore take up the SBD, may I just place the case in a proper perspective, lordship? But this is the crux of the matter.
Yes, Kichi, you have any instructions?
Lordship, as per my affidavit, as per the affidavit filed by the state, with regard to the with regard to the minutes, ignorance about 10/8/2023 minutes, it was stated that there was a meeting to be held on 12/1/2024. However, the petitioner did not turn up on that day, wherein that on that particular date, this minutes date 10/8/23 was brought into record.
So again, this is a submission that is not supported by the affidavit. The affidavit says, I did not appear in the previous meeting, and therefore, had I appeared in the previous meeting, I could have asked this question to them. Is the onus upon me or the onus upon them?
Where's the work order?
Yes, lordship. Work order is at page 512. And before that, if your lordship will see 510, wherein I had been adjusted as L1, 510. I am Vertex Construction, 18 crores, 34 lakhs. And the private respondent is SN Enterprise. He quoted 19 lakhs, 19 crores. Lordship, see in page 510.
Yes.
Vertex Construction is 18 crores 34, which is 0.35% lower than the estimate, while SN Enterprise, which is the private respondent, had quoted 19 crores, lordship. So it was higher than me by around 64 lakhs. I was adjusted as L1. Lordship has seen that, L1. Thereafter, since the work order was not published in the web portal, so I filed an RTI at page 511. Therein, I asked for the work order, if at all passed, and how did you pass that work order? And therein, in reply, they now give us at 512 the work order. Along with that, they give us a calculation at page 513, wherein by putting certain methodology, which is unknown to us, they make him L1. And they say this minus of the meeting. This minus of the meeting gives some methodology, which is also not very clear as to how they have applied it. And this is how they have now proceeded to work the order also. And the facts are not disputed here, that this is a document which does not form a part of the SBD.
Is the private respondent
Notice has to go to the private.
doing the work or not?
Number 4.
In terms of the work order, they have started work?
They have already started work, your lordship.
So my submission on that, lordship, our division bench have categorically stated that if someone proceeds when knowing that when a proceeding is going on, and in fact, in this particular matter, there was an interim order of this honorable single judge, wherein it says that if he does so, it will be at his risk and cost. Page 500 and at page 520, the order is there. So even if he works, it is at his risk and cost, lordship. That cannot be a ground to preclude your lordship from passing an interim order if illegality is there, prima facie. Lordship will come to 523, paragraph 9. 523, paragraph 9. A categorical finding was there. In view of the above, the court prima facie finds that the system by which the respondent authority stands to have allowed the quality cum commercial based system appears to be a hidden criteria on which the contract has been awarded is not permissible under law. And thereafter, the learned single judge at that occasion has proceeded to say that on being informed by the State Council, the respondents have started the work. It is made clear that the respondents may continue with the work at his own risk and cost. For the simple reason that although the court has found prima facie irregularities in the tender process, no order of stay of construction was passed purely in the public interest.
Mr. Hisham, I'll let it go. Miss. Miss. MPG. Leonard, Advocate General Naglik. Appears on behalf of the respondents, 1,
2 and 3.
2, and 3. Issue notice to the respondent. Appellant to take steps for service of notice on this
Or we can take dusty service.
by registered proceeding within 1 week. For additional. Appellant is also permitted to post service of notice on the respond number 4 by dusty service.
Yes, Your
to
Honor.
the registry of respond. Draft the appellant shall file an affidavit together. When can you have it? After 2 weeks?
Yes, Lordship.
List the letter.
First, we'll kindly give a date, Lordship.
List the letter. Give a date of it. Right for it.
And also, status quo as on date said we will maintain also.
That would be giving them the prayer for interim and the participate on the.
Or at least Lordship may also observe what was observed by a single bench at that point of time. If they proceed, it will be at their risk and cost.
No, that's why I'm saying we'll consider it on the next. Give a date.
26 June. 26. Obliged, Your Lordship.
There's no point in giving stuff as a open.
Item 4.
Lord, there were 3 petitions which were dealt with by the same judgment. Only one matter has come before Lordships and 2 matters have come before court number 6. So may I pray, my Lord, all these matters will be taken on 11 together, my Lord.
On request made by Mr. K. Chowdhury and their counsel for the appellants. List is read.
On
appellant
11, my Lord, Wednesday.
Along with.
Yes, but those 2 matters will inform the Honorable Court. Writ appeal number 191 of 25 and 193 of 25.
You got it, 191, read appeal, 191 of 25 and
And
190.
193 of 25. So 2 matters have come before court now. These are the main matters actually, my Lord.
Okay.
193 and 191.
You want?
On 11th, my Lord,
11.
Wednesday.
Item 5.
Lordship, matter relates to the advancement of third administrative benefit, Lordship. What should be the actual date, Lordship? They have been joined in 87, 88 and 89. 30 years they complete on 2017, 18 and 19. But they have been given on 2013 and 14. That we have corrected and sought to recover. A similar writ petition has been admitted and Lordship, interim order has been passed, Lordship. দুটা order আছে। Same Prasar Bharati, Lordship. Altogether 24 persons we have sought to correct, Lordship. And the matter may be taken along with these 2 writ petition, Lordship.
The similar matter.
Similar.
Now that on this, we have to state. Okay, heard. Mr. B. Chakravarti, Leonard CEC for the appellants.
Impugn orders, page 84. Lord.
No. Respondents,
3 respondents.
issue notice and respondents 1, 2 and 3. Appellant to take steps for service of notice. On all the respondents by registered post 80. This after 4 weeks. Along with WBC number 4628 of 2024. and 1286 of 2024. Correct?
Lordship, there is interim protection also. Lordship.
Till the next suitable date. Where's the order?
Imprint order page 84, Lordship. Order dated 26/2024, passed in 08
The order
08
dated-
of 20.
26/2024. Pass in OA number 040/00208/2021 by the learned Central Administrative Tribunal, Guwahati Bench, shall remain.
Deeply obliged.
Item 2. This has to go here.
Respondent number 2 has been served.
In the
As
writ
required by
the-
notice
In the writ petition.
in the writ petition.
But
This application,
IA.
IA is not separate, it is connected with the writ. Therefore, in the IA order, your lordship has not said that another notice will be issued.
So notice has not gone to respondent to.
No,
The
because
respondent
once they come to know about this proceeding or about the writ petition, they either take steps to have somebody appear on their behalf, or then it goes ex parte. If I file an interim application in that matter, I need not again, the court has not ordered that you again serve.
Respondent too will not know that you have filed an IA.
No.
How can-
Huh? Email has gone to the respondent number 2. কোনখানে interim ফোন নেই কোনখানে?
You take dusty service, we'll issue notice on respondent, we'll fix a date, and on that day we finish it. At least that notice, let it go.
They have received the notice. If they choose not, it is Union of India, my lord. Their counsel is here. They are appearing. That is noted.
In the writ petition. we have-
Doesn't matter,
we have-
my lord.
we have-
If
we have
suppose I
notice.
file a writ petition and notice is issued to the Union of India and the counsel appears. And then when I file an interim application, I will serve a copy on him. It need not, your lordships will not order that you again file, send notice and serve notice on them about the interim. No, it is not done.
Problem is
If the
nobody.
council appears, your lordships will not do that because the service is
That's fine,
complete.
that's fine.
Ah,
But none of the council is not appearing.
no,
Respondent two is not appearing.
R2 is appearing.
R2 is not appearing.
Respondent number 1 and 2. No, not central government, no. Kapini, you are not appearing for R2. You have appeared for R2.
The very first day I paid on one.
So what we are proposing.
No,
what we
one
are
of the
proposing-
orders reflect that he appears for R2. That's why I am saying that.
What we are proposing.
Yes, Nidha.
Will allow you to serve copy on the respondent two
Okay,
by dusty service if possible, if you want to do it.
Yes,
If
we'll
you
do
can't
that.
do it.
we'll do it. We'll do it. We have already done once, I will do it again.
Okay. Heard Mr. P.K. Goswami, learned senior counsel. Assisted by Mr. B.K. Goswami, learned counsel for the applicants. Issue notice on the respondent number 2. This is the IA. Stop.
Good deal.
Considering the urgency involved, the applicant is permitted to post service of notice on the respondent number 2 by dusty service to the
Will
registry of
do.
the spot within 1 week. Within a period of 1 week. Thereafter, the applicant shall file an affidavit to that. Stop. List the matter, give a date up to 2 weeks.
24.
Milord, your lordship will kindly note that this order of your lordship on 14/5/25, it records
That is in the writ.
it is directed until final disposal. Kindly see that order. It is directed until final disposal of the writ petition, no recovery shall be effected from the petitioner pursuant to the latest dated 28/1/25 and 12/2/25. These are the impugn orders. So this status quo is there. And we have served them on 15/5. After getting this order, we sent a copy of this order, and that affidavit is also on record. Therefore, they could not have violated this order by taking away the money. Whether it is respondent 1, 2, 3, 4, nobody could have done it. They were served.
We understand, we
Huh.
understand. But insofar the IA is concerned.
No,
what
no,
we are
because
saying, why not?
kindly,
Why
yeah,
not
may I
use
just-
post service?
yes.
Then after that, if they don't appear, that's fine. According to, we will pass final orders.
May I only say this? When they appear, when we serve the dusty service, they have what options? Two options. One, either they appear or they don't appear. If they don't appear, they take the risk. Will not file the interim applications, and every time your lordships will order that you serve copy again on them. Why should we do it? Your lordships never do it.
At least you let the respondent number 2 know that you have filed an IA asking for refund.
They have known,
Seven
because
lakhs.
we have already taken steps. Their counsel is there, he appeared, that is recorded, and your lordship is.
Respondent to counsel is not here.
No, it was recorded, he is appearing. There may be another dialogue between him and his client. We are not concerned, but your lordship's order says he appears for respondent number 2. Therefore, there is no ambiguity about it.
You take. We are fixing it on
24 June.
20,
24th of.
24th.
Ah.
Huh? Huh? What? Because it will not take so long to serve a copy, kindly prepone that. Because it is one account is virtually nil now.
19?
One week from today, that is, we will serve them on within how many? Less than 1 week. We will serve them because your lordship's order, we serve them also dusty.
Okay, 15.
15.
It's Sun.
15th is Sunday, I am told.
16.
16th.